Hey folks, if you love drama inside the courtroom, get ready for May of 2019. Court TV is back. We'll be on the air with gavel-to-gavel live trial coverage of the biggest cases in the nation.
Good afternoon, Your Honor. Dalia Romero, Spanish interpreter for the record, already sworn.
Madam Interpreter, do you mind if I do?
Testosterone.
Julie, do you have somewhere else to be?
Childish.
Can I do my Spanish interpreter first? Okay, I'm going to do Spanish interpreters, sign language interpreters, PD's cases, and then Mr. Reese's case finally.
I vote for Mr. Reese's case at the very end of the docket, the last case.
So the sign interpreter case is the first case on top. So the rest is.
All right, thank you. Madam Interpreter, have you been sworn in yet? Madam Spanish Interpreter, have you been sworn in?
She's talking, but we're not hearing her. I see her.
I can't hear you broadcasted, so I can hear.
You can hear the headsets, but you cannot hear me broadcast?
Now I can hear you.
Okay.
Okay.
Sorry.
Ernesto
Yes, I was sworn.
Ventahino, too? Oh, come on.
Chase, he can't sit down. He can stand. He's fine.
Sir, what is your name?
Ernesto Batengastu.
Do you want a public defender that's a lawyer to help you with your case?
No.
All right,
No.
sir. If you change your mind during our conversation and you want a lawyer, let me know. Sir, you were arrested for a new charge of no valid driver's license. You're already out on bond for an old charge of no valid driver's license. I find probable cause for these offenses. There is an immigration hold on him. Any objection to me just increasing his monetary bond on the old one and taking no action on the other case?
Your Honor, my concern would be that he's committing the exact same charge.
Yeah, I was going to do a higher bond on this.
That's fine, Your Honor.
Okay, in case number 19 CT 117, I'm going to increase your bond to $2,000, but I'll take no action in case number 18 CT 9257. Sir, after you post your bond, there is an immigration hold, and ICE may be meeting with you. Are you sure you don't want a lawyer?
No.
Okay, thank you.
Yeah, he gets his bond on those. He didn't get for the PTD though. He ain't going.
Sir, what is your name?
Mike Hernandez.
Mr.
Mike
Hernandez,
Hernandez.
do you want a lawyer to help you with your case?
No.
No.
Sir, you need to try to get a valid driver's license. You were arrested for no valid driver's license. I find probable cause. I'm going to put you on pretrial release. Appear for all future court dates. Do not commit any new law offenses, illegal offenses, and try to get a valid driver's license. Thank you, Mr. Hernandez.
No objection from the state, Your Honor.
Thank you.
Your Honor, may I have a case number, please?
Yes, ma'am. That case number is, can you read that?
2019 CT 122AO.
Thank you.
Thank you. Sir, you're here in case number 2. What's your name, please?
Carlos Laguel.
Carlos Lag.
Sir, you were arrested for a charge of resisting officer without violence as well as possession of cannabis. I find probable cause for those offenses. I'm also aware that you are on probation in case number, hold on a second. In case number 2018, CT 8016AO. In that case, I'll also appoint a public defender to help you with that case. Has a warrant been served on that?
Not yet, Your Honor, but he's out on bond on the CT case as well.
Okay. Okay, I just reviewed, sir, I just reviewed your violation of probation. I'll go ahead and proceed with his IA right now. He's being held at no bond in case number 18 CT 8016. Sir, you are on probation for no valid driver's license. It's alleged that you committed a new law offense of resisting officer without violence, possession of cannabis. You didn't pay your court cost and supervision. You tested, you had marijuana, and you didn't comply with collections court. So in that case, you'll be held at no bond status. Defense counsel and state in 18 CT 1003AO, that case was null prost.
Your Honor, the case you just mentioned, county probation, he's not here on that.
Okay.
But I believe I met one of the probation officers on the elevator. She was en route to try to have that warrant signed.
Yeah, it was signed already.
Oh, okay.
It's already imaged in Odyssey, ma'am.
Oh, okay.
All right, so the public defender's office will help you. It looks like you're raising your hand like you want to say something. All of your statements can be used against you, and they can be used to prove the new law offense and the violation of probation. So I'll give you a moment to speak with your attorney. Anything else, defense counsel?
I know, you're staying the bond at 500 and 100,
Yes, I'm going to stay at those bonds on the new offenses.
and there's no, are you taking no action on the Allen bond charge?
The out on bond that I mentioned was already null prost, but he's on probation, and in that case, he's being held at no bond.
The probation case is already done, or are we going to review by court?
I'm going to do it on view by court.
Okay. Have the case number?
Yes, that VOP case number is 2018 CT 8016, ma'am. Thank you. David Perez Batista is next. Sir, what's your name?
David Perez Bautista.
David Perez Bautista.
Sir, I'm appointing a public defender to help you with both cases that I'm addressing. Sir, you're on probation in case number 17 CT 9742. You're being held at no bond status. You were placed on probation for alcohol-related reckless driving. The officer has done what they call an on-view violation because I find probable cause in case number 19 CT 133 and 134 for charges of driving under the influence with property damage, as well as driving with license suspended as a subsequent offender. In the new case, I'll stay those bonds, but you'll remain at no bond status on the other case. Sir, Mr. Perez, how often are you paid $2,500? Do you get paid weekly, every 2 weeks, twice a month, or every month?
Variado. Tengo 4 hombres trabajando conmigo. Les pago semanal.
It varies. I have 4 men working with me, and I pay them weekly.
So what is your take-home pay?
Okay. Dependiendo, $1,000 por 15 días o $800.
It depends. $800 to $1,000 every 2 weeks.
Okay, thank you, sir. Again, the public defenders will help you with your case. I'm also going to order in both of these cases that you not possess, use, or consume any alcohol or any illegal drugs. Thank you, sir.
Okay.
Your Honor, the next one, the victim needs the interpreter.
Okay. Sir, what's your name?
Felix David Hernandez Garcia.
I have it here, Judge.
Thank you. Mr. Hernandez Garcia, you do not qualify for the public defender based on your affidavit. Let me ask you some questions, though, just to be sure. How often are you paid at your job?
Bi-weekly.
And how much is your take-home pay after taxes and withholdings?
After taxes is $900 and $940.
Do you support anybody?
No, just my wife.
Does she work?
Yeah, she does.
So, sir, you make too much money to qualify for a public defender. You'll need to hire your own attorney if you would like legal representation. If at a future court date you still cannot afford to hire your attorney, let a judge know, and we can see if you qualify at a later time. Mr. Hernandez Garcia, you're here for a charge of battery domestic violence, and I do find that there's probable cause for this offense. Madam Interpreter, can you broadcast? Ma'am, please raise your right hand.
Señora, por favor, levante su mano derecha.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
¿Usted solemnemente jura o afirma que el testimonio que va a presentar es la verdad, toda la verdad y nada más que la verdad ante Dios?
Sí.
Yes. Gracias.
Are you Miss Otero?
Sí.
¿Es usted la señora Otero?
And how do you know Mr. Hernandez Garcia?
¿Cómo conoce usted al señor Hernández García?
Amigo.
We were friends.
Are you in a relationship with him?
Ya. Sí.
¿Usted está en una relación con él? Yes.
Do you live together?
Sí.
¿Viven ustedes juntos? Yes.
Are you afraid of Mr. Hernandez Garcia?
¿Usted le teme al señor Hernández García?
No.
No.
Do you want to continue to live with him?
¿Usted quiere continuar a vivir con él?
Sí.
Yes.
And do you want to have contact with him?
¿Y usted quiere poder tener contacto con él?
Sí.
Yes.
Was alcohol involved?
En todo esto, el alcohol
Was
fue
he
un
drinking or
factor.
using alcohol or drugs?
¿Él estaba tomando o usando algunas drogas ilícitas?
No, estaba usando drogas.
He was not using drugs.
What about alcohol?
¿Y qué del alcohol?
Un poco.
Some.
State your witness.
Has anything like this happened in the past?
¿Algo como esto ha ocurrido anteriormente?
No.
No.
If something happened in the future, would you feel comfortable in calling the police or 911?
¿Usted se sentiría cómoda en el futuro si esto volviera a ocurrir en llamar al 911 o a la policía?
No.
No.
So you would not call the police if something happened in the future between the two of you?
Así que usted, si algo pasara en el futuro como esto, ¿usted no va a llamar a la policía?
Sí,
¿O al
sí.
911?
Sí.
Oh, yes, yes.
No further
Yes.
questions.
Disculpe.
State, what's
I'm
your
sorry.
position? State, what's your position on the pretrial release program for
State would
this?
object to PTR based on the nature of the charge.
Okay. Mr. Hernandez, over state's objection, I'm going to set your bond at $500 or put you on the pretrial release program, which is a non-monetary program, but you have to report once a month. Do you know what you'd like to do? Post monetary bond or do pretrial release without having to post any money?
Sorry, could you repeat?
Money bond it's a $500 bond, or I can release you without having to give any money, but you would have to pay a smaller fee. It's, I think, $39 for a 3-month period, and you have to report to pretrial release office once a month to check in.
I prefer the second option.
Okay. Sir, I'm going to put you on the pretrial release program. Madam Interpreter, can you interpret everything out loud?
Yes, Your Honor. Señora,
Okay, go.
al señor se le dio dos opciones, una de pagar una fianza monetaria de $500 o un programa que se llama Pretrial Release, donde se les requiere a él pagar $39 al mes por 3 meses y tiene que reportarse mensualmente.
Sir, you're not to have any hostile contact with Miss Otero. You can't do anything to harm, threaten, scare, or intimidate her.
Señor, usted no puede tener ningún contacto hostil con la señora Otero. No puede asustarla, intimidarla, hacerle daño, agredirla en ninguna forma u otra.
You're also not allowed to possess any weapons.
Tampoco se le permite poseer ningún tipo de armas.
If you own any weapons, they need to be surrendered to the police department within 6 hours of your release.
Si usted es dueño de algún tipo de armas, una vez usted salga, tiene 6 horas para entregárselas al departamento de policía.
And I'm also ordering that you not possess, use, or consume any alcohol or any illegal drugs.
También estoy ordenándole que no puede poseer ni usar ningún tipo de alcohol o drogas ilícitas.
That ends your case. Do you have any questions, ma'am?
Eso culmina su caso. ¿Alguna pregunta, señora?
No.
No.
Sir, do you have any questions about your release conditions?
Señor, ¿usted tiene alguna pregunta en cuanto a las condiciones de libertad?
I don't have any questions.
All right, thank you both.
Gracias a ambos. Your Honor, may I have a case number, please?
Yes, that case number was
2019 MM 183AO.
Thank you.
Thank you.
Is that the last case for the interpreter?
Is that everything for Spanish interpreter? Okay, thank you. Let's go to sign language interpreter. Have you been sworn in, Julie? Please raise your right hand.
Do you solemnly swear to to interpret from English to signs, from signs to English, whole truth and nothing but the truth, so help you God?
I can't swear that I believe that truth.
Okay.
I can interpret accurately to the best of my ability.
Thank you.
All right, thank you. Sir, please tell me your name. Mr. Johnson, you were arrested for a charge of possession of cannabis with intent to sell or deliver, as well as possession of drug paraphernalia. I'm going to appoint a lawyer from the Public Defender's Office to help you with your case. Sir, I find probable cause for these offenses. I'm going to stay your bond on count 1 at $1,000 and release you on your own recognizance on the possession of drug paraphernalia. Your total bond is now $1,000. Thank you, Mr. Johnson. What's his name? Pardon me, Mr. Reese, what's your client's name?
Mohammed.
Got it. All right. On record on 2 different cases. And thank you. Oh, was there 3? Thank you. So there's 3 different cases for this gentleman. Case number 18MM6388AO. Defendant has a court date of February 4th for a charge of possession of drug paraphernalia.
Pre-trial intervention status.
Okay, he's PTI. And then what about case number 18CF1036A?
I believe that's February 24th, I think, for a pre-trial diversion status.
What judge is that in front of, sir?
Whoever now is Judge Lubit.
Judge Schaefer, maybe?
I have Judge LeBlanc in Division 22, 18 CF 10368.
Okay. All right. Mr. Lodi, you're here for new case. That case number is 19 CF 322AO. You're already out on bond on other cases. You were arrested for possession of heroin, possession of cocaine, and possession of drug paraphernalia. I find probable cause for these offenses. State, do you want to be heard on all 3 matters?
Your Honor, it looks like maybe those 2 cases, the 2 heroin cases, 18 CF 322 and, no, I'm sorry, 18 CF 10368 and 18 MM 6388 may have been a pretrial diversion. We'd ask that the bond be revoked and new bonds be set on those cases. We'd also ask for RUA through pretrial release and 1 NA or AA meeting a week.
All right, defense counsel?
Your Honor, the state and I spoke about that, and we have no objection. The new case, Judge, to be perfectly candid, I don't know how much time you spent with the charging affidavit, but it's a constructive possession case, jointly occupied vehicle that I don't think we pursued by the state.
You don't believe what?
I don't think the case is going to be filed based upon my experience.
Okay. But still, there is probable cause. So here's what I'm doing. Sir, on all 3 of these, so on your new case, I will do an increased bond on the heroin. Not an increased bond. I'll stay the bond on count 1 at $1,000 plus pretrial release. Count 2, $100 plus pretrial release. I'm sorry, $150 plus pretrial release. And count 3, straight pretrial release. In case number 18MM6388AO, I'm revoking your bond, setting you a new bond of $2,000. Actually, strike that. Just do a straight pretrial release. And then in 18CF10368AO, I'll do a bond of $1,000 per count plus pretrial release. Mr. Lodi, through the pretrial, do you need a minute? Okay. So I'm putting you on a mix of monetary bond and pretrial release. I'm specifically ordering that you have no contact with Mr. Silverio, the co-defendant in the newest case. Does he need to have contact with him for any? Thank you. I'm ordering that you not possess, use, or consume any illegal drugs or have any drug paraphernalia. I'm also ordering that you not possess any alcohol. Testing for alcohol through the pretrial release program can be done at any time. Testing for drugs can begin any time after February 7th. I'm also ordering that you have documentation that you attend 1 NA or other drug prevention or anti-drug use course per week or counseling courses per week. But you need to give your attorney all that paperwork to certify that you've been going there. Do you have any questions?
No, thank you.
Anything else, Mr. Reese?
Ma'am?
Ms. Kennedy Swanson, anything else?
No, Your Honor.
All right, thank you. Yeah. And show proof to pretrial release too. Thank you. Oh, I went out of order. I'll figure it out. Okay, who's next? Cameron Bennett. You okay? Mr. Bennett, you're here for case number 18 CF 12287. You missed your court date. If you don't have a public defender, Mr. Bennett, I'm going to appoint one at this time. Because you missed your court date for possession of a controlled substance as well as possession of drug paraphernalia, you're now being held at no bond status.
Miss, can I say something?
I'll let you speak with your attorney before you say anything. All of your statements are being recorded and can be used against you. I'll give you a moment with your lawyer.
I allow it if I say I agree. I see the second case. Hold on. Let's see.
All right, Your Honor, despite my legal advice, I'm glad I protest the court.
Yes, sir.
Far as that court date, they sent me 2 letters in the mail saying that I was all right with the case because I had already did my time served for it. Now, as far as that, after I got the message, as far as my mom, because I have it in her address, I don't stay with my mom no more. I stay in the hotel room.
All right.
I've
well,
been there for the past couple weeks now.
One of your obligations when you're out on release conditions is to keep the court and your attorney updated as far as where you are living.
Ma'am, I understand that.
I see that the mail was returned. You can set your case. Your attorney can set your case for hearing in front of Judge LeBlanc for any modifications. But in the meantime, you'll be held at no bond status. Your name, please.
Evan Cameron.
Good morning, Mr. Cameron.
How
Good
you doing?
afternoon, rather. You're here for felony case number 19, CF 326. I'm going to appoint a public defender to help you with your case. Sir, you're here for possession of a concealed weapon or firearm by a convicted felon. You're also here for possession of cannabis greater than 20 grams with a weapon, possession of cannabis with intent to sell or deliver, possession of a narcotic, a synthetic narcotic, as well as possession of drug paraphernalia. State, the affidavit does say something about a convicted delinquent, which is a different statute. I don't see anything on his history, though, for count 1.
And 1 moment, Your Honor. What's his date of birth?
I'm showing his DOB is 12996.
It looks like I have a
Sir, you do have a right to have a confidential communication with your attorney. You're speaking rather loudly, so I don't want you to waive that privilege.
Excuse me, I'm sorry.
So he had a 2015 dismissed no valid driver's license. Then I showed that he had a 2011 CJ case that was null prost, according to our system.
So I don't have probable cause for that offense, State. Do you want me to find PC to a lesser? Well, does he have a permit?
Yes, he does have a permit, Your Honor.
Well, that's not. State, what do you want me to do with count 1? Any request? Remember, it was carrying a concealed defense counsel. I don't want to put anything.
Is it not lesser included? Let's see.
Well, reading the rest of the affidavit, I believe that the firearm was found under the seat, Your Honor, and the state of Florida, you don't need it's not concealed unless it's on your person or readily accessible, am I correct? Right.
Okay.
It wouldn't actually be a
Mr.
crime
Thompson.
unless it was.
That's not the law. That's not the correct law.
State,
I'm trying to see the lesser included possession of.
carrying a concealed firearm is an M1 pursuant to Florida Statute 790-012.
State's okay with finding the lesser included carrying concealed and treating count
1 as the primary? 2 rather.
2 as the primary, yes, Your Honor.
Defense, do you want me to find it pursuant to the lesser? Because that's what I'm going to do.
Okay, Your Honor, however,
Do you want to say?
excuse me, Your Honor, but unless the firearm was on his person,
You want to read the statute again?
yes, I would like to.
Go ahead. 790. .01 sub 14.
Your Honor, I'll still object. I would argue that it wasn't about his person, and the house and the car basically treated the same under the statute, and it's not concealed unless it's on his person.
I believe it says on or about.
Hold on,
But in the car itself, the car is treated,
hold on,
it's given the same constitutional privilege as a home, and you don't need a permit to have a firearm in your home or in your car, but you do need one to conceal one on your person.
Okay.
Or about your person outside of the car.
It is under the seat. Let me just double check the jury instruction on it.
I'm looking at the jury instruction. I see the Supreme Court has updated their website.
It says it.
It
All
says
right.
defendant knowingly carried on or about his or her person a firearm, a weapon, or an electronic weapon
So
or
defense,
device.
if I gave the state, let's just think about this, if I gave the state up to 48 hours, he'd be sitting at $5,000 bond. How do you want me to proceed, defense counsel?
I would not want him to sit for 48 hours. I was going to take it
I'm
off.
sorry, I can't hear you.
I would not want him to sit 48 hours while the state gathers probable cause.
So I'll go ahead and find probable cause as to count 1 under Florida statute 790.01, sub 1. It's a misdemeanor offense. I'll set that bond at $100. Count 2, I'm going to set that bond at $2,500. Count 3, 4, and 5, I'll stay the bond. Mr. Cameron, I'm ordering that you not possess any weapons or ammunition. All weapons and ammunition need to be surrendered to the police department within 6 hours of your release from jail. Additionally, you're not allowed to possess, use, or consume any illegal drugs or any drug paraphernalia. Thank you, sir. What?
Anthony Rogers.
Okay, Anthony Rogers. What's your name, sir?
Randy Cox.
Okay, Mr. Cox. Mr. Cox, you qualify for a public defender. I'll appoint them to help you with case number 19CF317. Sir, you were arrested for grand theft, motor vehicle fleeing, attempting to elude a police officer with lights or sirens activated, as well as no valid driver's license. Mr. Cox, you are entitled to a bond as to count 2. I do find probable cause. As to count 1, I'll set your bond at $150. As to count 2, I'm setting your bond at $3,000. And finally, count 3 will be stayed at $100. You're not to have any contact with the co-defendant, nor are you to have any contact with the victim car owner. There is a hold for his violation of probation status out of Brevard County. Your name, ma'am?
Antonia Rogers.
You said Rogers? Counsel, give me just a moment to pull her paperwork out.
2 VOPs, Your Honor.
Case number 14 CF 1642AO, as well as case number 14 CF 16741AO, 2 violations of probation, each for dealing in stolen property. Appearance for the record, please.
For the record, Tim McLean on behalf of Antonina Rogers, who is present, standing to my right.
All right. So in both of these violations of probation, she's here because she did not pay her cost of supervision, and she did not pay her court cost and fine. I'll enter a denial at this time, but she's being held at no bond status per the warrant. Is there anything else I need to consider, Mr. McLean?
Yes, Judge. I would ask the court to consider the fact that today would have been the last day of her probation. She was expecting a child. The state and I have agreed to a $1,000 bond on each case. However, in light of that, I would ask the court to consider the fact that she's already having financial problems, to consider ROR if possible. But the state has agreed to a $1,000 bond, but the court could consider ROR.
I could consider it, but this is a subsequent violation of probation, as I understand it, and this was a warrant signed by the judge, so he's familiar with the facts.
Yes, ma'am.
And she was already she's on probation. She already had a prior violation for a new offense. At this time, I'm going to deny that request to modify the bond and keep her at no bond status.
She said she never had a violation of a new charge. Judge.
May I have one moment, Your Honor, to look at this case.
Yeah, she's never violated on this one, Judge.
4 years.
Let me double check
In
it.
the in the 14 CF 16742, I don't see a VOP in our system. It's like she pled a
I see what's going on.
3 years probation on that case.
Okay, so I was mistaken.
Yeah, and it would have been over today.
It's same for both. I don't see a VOP in either.
Right.
Your Honor, I'm gonna put the DOCs.
What's her Seminole County case?
2014 CF 3878AO.
Yeah, she's still on probation for that one.
Okay.
And it ends next month, so she was kind of doing them at the same time. But both was being supervised by Orange County.
Because she's working and she didn't do anything, I think these are all the considerations the warrant judge had in signing these warrants. I'm going to continue to hold her at no bond status.
Will she have an arraignment?
She'll have an arraignment probably within 7 days in front of Judge Whitehead.
Yeah.
You might be able to get a modification in front of Judge Traver in the meantime, or prior to that date. Sir, what's your name?
Richard Davidson.
All right, you already have a public defender in case number 2018 CF 4567. Let me look at that case. So you're out on release for attempted first-degree murder and shooting from a vehicle. where you might be out on ROR. And then you're also here in case number 19 CF327 for the new offense of, 19 CF328 for aggravated assault with a deadly weapon and violation of injunction. And then in case number 19 MM190, you're here for violation of stalking injunction. And then you have an open case in 18 CF4234. State, talk to me about and I'm appointing a public defender in all of these cases. State, can you please address the out on bond cases?
So in 18 CF4567, there was a competency hearing that took place in December 21st of last year. I'm trying to see what the notes.
He was found competent to proceed.
Correct, so it has a pretrial date of 4/2 of 2019.
Okay.
So he asked the bond be revoked on that case and he be held at no bond.
Do you know if it was the same victim as this domestic?
The victim in the out on bond case is
Well, not domestic, but the stalking.
UCCIFERI is the last name. Let me go to the new case. Yes, it's the same victim as a violation of the injunction case, as the felony case. And then for the misdemeanor 18 MM10941, that case has a pretrial conference January the 17th in Division 80, Judge Shoemaker.
All right. Defense counsel, do you want to be heard?
Your Honor, we'll just ask that you take no action on the Allen bond charge or an alternative to revoke bond and set a new one in this case, Your Honor, and that's all.
All right. In both the out on bond cases, we're dealing with violent offenses, and then we have new violent offenses. In 18 CF 4567 and 4234, I'm revoking his release, holding him at no bond status. Any modifications can be heard in the trial division. In case number 19 CF 328, the aggravated assault with a deadly weapon, I'm ordering no contact with the victim, that you're not to possess any weapons, weapons to be surrendered within 6 hours of your release, and abide by all terms of the injunction. On count 1, I'm setting your bond at $3,500. On count 2, I'm setting that bond at $500. In case number 19 M190, the violation of an injunction, I'm setting that bond at $1,000. Abide by all terms of the injunction, no weapons, and no contact with any victims or witnesses, Mr. Davidson.
Your Honor, since these crimes all stem out of the same occurrence, would you have any objections to picking one as a primary and setting the next two as subsidiaries?
I'm going to deny that request based on his ongoing criminal conduct. Allegations of ongoing criminal contact. The next person is Dewan. What's your name, sir?
Dewan Gines.
Mr. Gines, I'm going to, do you want a public defender to help you with your criminal charge?
What is going to be him?
For now, yes.
For now? I have to accept that.
So there's a $50 application fee to see if you qualify. Do you work, sir?
Say it again?
Do you work?
Yes.
How often are you paid?
I work at an express temp service, so once a week I get paid every week.
And what's your take-home pay after taxes and withholdings?
Depending on my hours. So if I'm working 7 days a week, maybe about $500, $600.
Do you support anybody?
Yes, I have a child and my grandmother.
So 2 people, 2 dependents, $500 a week? I'm going to appoint a public defender in case number 19 CF 320AO. Sir, you were arrested for possession of imitation substances with intent to sell, possession of burglary tools, petty theft, and loitering and prowling. I find probable cause for all those offenses. I'm going to stay those bonds and no return to the scene of the crime. Your total bond is $1,350.
Oh, you said a plea?
There's no plea offer on your
Oh.
case right now, because it's a felony.
Which one is a felony, ma'am?
The possession of burglary tools and the possession of imitation substance, synthetic substance with intent to sell. Your attorney can further advise you. The next person is Matthew Glover. All right, I do find probable cause for the new offense of possession of heroin and possession of drug paraphernalia. I'll temporarily appoint the public defender, reset both matters till tomorrow. Roosevelt Hemphill.
I got out of here with you, just out confirm with my client.
On Glover, I just appointed the public defender temporarily. He was behavior or medical, and he's reset till tomorrow, but I did find probable cause. Are you Mr. Roosevelt Hemphill?
Yes, ma'am.
Sir, I see an information has been filed in case number 18CF1697AO. In that matter, you have a public defender. You were charged with burglary, structure, criminal mischief with damage of $1,000 or more, and petty theft. Then you also have a second case where you're already out on bond or release. That case number is 2018 CF 17159.
What's this defendant's last name, Your Honor?
This is Mr. Roosevelt Hemphill. And in that case, charges have not been filed from that December 9th bond date. Actually, there's a third case. Case number 2018. Third and fourth case.
In the 16970 case, the state has filed an information.
Okay, I have that. 970, but I don't see anything was filed on 159.
On the 18 CF 15642, the state has not made a charging decision on that one.
And what about the final one, which is 18 CF 17244, ma'am?
In 18 CF 17244, the state has not made a charging decision. However, that case is not outside of the 33 days.
I agree with that. And he was out of custody at the time. So, sir, then you're also here for a new charge of grand theft motor vehicle. In every case that I've addressed, I'm going to appoint a lawyer from the public defender's office. Now, I know I had a conversation with the state about your other cases. That was December 22nd of 2018, so after he bonded. State, what's your position on any of these cases?
We'd ask that all of the bonds be revoked. He be held at no bond on all the out on bond cases, even though the state has not filed on some of them. It's because of the short time between arrests. He's been out on bond and continues to commit new theft-related offenses.
Defense counsel, anything else I need to consider?
Your Honor, I would ask that you take no action on the out on bond charges or an alternative to revoke bonds and set new ones. Your Honor, our client is very young. He's hasn't proven himself to be a threat to community substantially, Your Honor. And we would like the opportunity for him to fight his charges outside of the Orange County Jail, Your Honor, because to revoke his bond may hinder that process for him. That's all, Your Honor.
Okay, give me a moment to look at the new law. I just want to make sure it was subsequent.
And I may think that I want to make sure that this the new charge isn't a warrant arrest.
It is a warrant arrest. Okay, and it was a warrant, that incident was alleged to have occurred on December 22nd, so here's what I'm doing. I'll follow your request defense counsel in part. In 18 CF 1697AO, the charges have been filed. I'm revoking your release and holding you at no bond status. In case number 18 CF 17159, I'm revoking your release, but I will give you a new bond of $2,500 per count. In 18 CF 15642 and 18 CF 17244, I'm revoking your release and setting bond at $2,500 per count. And I'll stay the bond in 19 CF 188 with no contact with any of the co-defendants or the victim of that grand theft auto.
Judge, you said on case 2018 CF 16970, no action.
Wait, no, 16970, that's the one that has been filed, so I'm revoking his bond and holding him at no bond. Your name, sir?
Christopher Johnson.
2018 CF 11178AO. Mr. Johnson, you're represented by the Public Defender's Office for a case where you have trial pending for possession of cannabis with intent to sell or deliver, possession of cannabis greater than 20 grams, possession of cocaine, possession of drug paraphernalia, and another count of possession of cannabis with intent to sell or deliver. And then in case number 2018 6216AO, you're out on release conditions for a charge of battery, domestic violence, and criminal mischief. And in that charge, you have trial pending on January 22nd. So you're already out on bond on 2 different cases. And then you're now here on a possession of cocaine and possession of MDMA charge. In that matter, I'm appointing a public defender and I find probable cause. I'll stay those bonds, but based on the ongoing criminal allegations, I'm revoking your release in both your other cases and holding you at no bond status, Mr. Johnson.
I'm sorry, can you give me the case numbers? Oh, never mind. Figured it out. Thank you. Sorry, Your Honor.
Chip Check Joseph is next. The next person is Chip Check Joseph.
Yes, ma'am.
Sir, I'm going to appoint a public defender to help you with your case. Case number 19 CF 313. You were arrested for possession of tetrahydrocannabinol oils, possession of cannabis, and possession of drug paraphernalia with intent to sell. I find probable cause for all of these offenses. State he has an extensive misdemeanor history with violations of probation, but does qualify for pretrial release. What's your position on that?
No objection to PTR.
All right, I'll put you on the pretrial release program with the condition that you not possess, use, or consume any illegal drugs or have any drug paraphernalia. You'll be subject to random testing for drugs anytime after February 7th, sir.
Would you be appointed, Your Honor?
Yes, I appointed the PD's office.
I'm sorry.
Sir, what's your name?
Silverio Rizzoli.
Officer, what happened to McFadden? Okay. He is a detainer on the possession of heroin, 19 CF 324. I'm going to appoint a public defender. I find probable cause reset till tomorrow. Okay, sorry for the wait, Mr. Silverio. Mr. Silverio, I don't believe charges have been filed. State in case number 18 CF 14600AO for heroin, paraphernalia, and L&P. He does have a public defender. State, let me know.
What's the case number again?
18 CF 14600AO.
In that case, the state has not made a charging decision.
Okay, based on the age of that case, I'm going to take no action. In case number 19, CF 321, I'll stay the bond on count 1, count 2 modify to 150, count 3 modify to 100. Mr. Silverio, I'm ordering that you not possess, use, or consume any illegal drugs or have any drug paraphernalia. I'm also ordering no contact with Muhammad Lodi. Yeah, that was Adam's claim. Ma'am, what's your name?
Pilar Wright.
Miss Wright, good afternoon. You're here for felony case number 2019 CF 319AO. I'm appointing a public defender to help you with your case. You were arrested for possession of a counterfeit driver's license, conspiracy to utter a forged instrument, and grand theft auto. I find probable cause for all of these offenses. I'm ordering that you have no contact with the witnesses or victims of these crimes, no return to that Alamo rental or any Alamo location. I'm going to stay your bonds as listed, so your total bond is $2,800, ma'am. Your name, ma'am?
Kresge.
Ma'am, I'm not sure if you qualify for a public defender. Are you paid every month at your job?
It's here and there, ma'am.
So how often do you get a paycheck?
It's not very often.
And when you do get a paycheck, how much is it?
It's only maybe $50 a month.
Oh, that's 50, not 5,000. Okay. That's 50, not 5,000.
Okay, I just put it.
All right. So I'll go ahead and appoint a public defender to help you with your case, ma'am. You're here for case number 19 CF 316. You were arrested for possession of methamphetamines and possession of drug paraphernalia. You're also here in case number 19 CT 135 for possession of, driving with license suspended. I find probable cause for all of these charges. I'll stay the bonds in the felony case and reduce your bond to $100 on the driving with license suspended. Your total bond is $1,200, ma'am. You're not to possess, use, or consume any illegal drugs. What's your name, sir?
Evans Morgan.
Give me one moment, Mr. Morgan. What happened to Willis Brooks? Did he bond? Okay. Mr. Morgan, you're here for a charge of resisting officer without violence. I'm appointing a public defender to help you with your case at 19 MM 186AO. I find probable cause. I'll stay your bond at $500. State, do you have an offer on this case?
5 days.
It's a 5-day offer, otherwise his bond is $500.
How much?
I have 7 prior felonies, 10 misdemeanors.
Got it.
He would accept the state's offer and to plead no contest.
All right. Mr. Morgan, are you entering a plea of no contest to the crime of resisting officer without violence?
Yes, ma'am.
And do you understand that if you were on probation at the time you committed this criminal act, your probation terms would be violated?
Yes, ma'am.
Do you also understand that if you're not a United States citizen, you will be subject to deportation by pleading to this charge?
Yes, ma'am.
Sir, if you have a criminal history of doing anything sexually violent or anything sexually motivated, under the laws of the state, you would be civilly committed. Do you understand that too?
Yes, ma'am.
Officer, can you hand him a plea form? Sir, did you read that paper in front of you?
Yes, ma'am.
If you agree to the terms and understand the rights you're giving up, go ahead and sign it. Mr. Morgan, at this time, I'll accept your plea of no contest. You're hereby adjudicated guilty, sentenced to 5 days in the county jail with credit for 1 day time served. Pay your court costs by January 30th of 2020. And sir, you have 30 days to appeal the judgment and sentence in writing. If you can't afford an attorney, one would be appointed. Thank you, Mr. Morgan. Luis Alberto Rizzoli. Sir, your name, please? Are you Mr. Rizzoli?
Yes, ma'am.
Mr. Rizzoli, you're here for misdemeanor case number 19MM18880. You were arrested for a charge of petty theft. I find probable cause. I'm going to stay your bond at $250 and no return to Circle K. I'm also going to appoint a public defender to help you with your case. State, do you have an offer?
No, Your Honor.
I don't see that he has any prior thefts, but I do have other history. Any objection to the court making an offer? With a reservation as to, well, he's $1.
The restitution is $1.60, Your Honor.
With the restitution of $1. Do you want an offer on this case? Defense?
Yes, we'll hear offer, Your Honor.
The offer on this matter is an adjudication, 4 days in the county jail with credit for 1 day time served, pay restitution of $160 to Circle K, no return, and abide by all trespass orders.
He has prior convictions on the record, am I correct?
What?
Yeah. Is there prior criminal convictions?
He has a prior conviction for DWLS, battery, domestic violence, and 2 no valid DLs. So this is his first theft.
I will accept the bench's offer and enter a plea of no contest, Your Honor.
Mr. Rizzoli, are you under the influence of any drugs, alcohol, or medication that's affecting your thinking or understanding?
No.
Did you read the paper, the plea form in front of you?
Yes.
Do you understand that theft is an enhanceable offense? Today you will be convicted. If you commit a future act of theft, you may be charged with a felony despite the value of the item. Do you understand that too?
Yes.
All right, and how are you playing to the charge of petty theft? Guilty, no contest, or not guilty?
No contest.
Do you understand if you were on probation when you committed this act, your terms of probation would be violated?
Yes.
Do you also understand that if you're not a United States citizen, you will be subject to deportation by playing to this charge?
Yes.
And Mr. Rizzoli, if you have a criminal history of doing anything sexually violent or anything sexually motivated under the laws of the state, by entering a plea, you would be civilly committed. Do you understand that too?
Yes, ma'am.
In front of you, there's a plea form. Did you read it and understand it?
Yes.
If you agree to the terms and understand the rights you're giving up, go ahead and sign it, Mr. Rizzoli. Mr. Rizzoli, at this time, I'll go ahead and accept your plea of no contest. You're adjudicated guilty, sentenced to 4 days in the county jail with credit for 1 day time served. In addition to your court costs and your public defender's fees, you do a $1.60 cost of restitution to Circle K, located at 6949 Silver Star Road. You need to abide by all trespass orders, no return to the scene of the crime. When you go in back, you'll be fingerprinted for conviction and enhancement purposes, and you have 30 days to appeal the judgment and sentence in writing, sir. That ends your case. Good luck to you, sir. All right, State, let me go to these 33-day motions. I've seen some of them. Joshua Duncan, 18 CF 17227, deny the motion. Information has been filed. In Mr. Duncan's second case, 18 MM 10999AO, it was filed in circuit court. I'll deny that motion. Justin Campana, his case number is 2018 CF 17112AO. That was filed in county court. That motion is hereby denied.
Court TV is back, folks. May of 2019, we relaunch. We'll be on television. Gavel-to-gavel coverage of trials. If you love courtroom drama, this is the place to be.
The right to an attorney to represent you, and if you desire to be represented by an attorney but cannot afford to hire counsel, after making the appropriate inquiry, the court will appoint counsel to represent you. The court will also make a determination as to the reasonableness of your bond. In order to fulfill those functions, it may be appropriate that I speak to you. But no question I ask, nothing I say, should invite you to talk about the case or the facts of your case, because anything you say at this proceeding may be used against you at the trial and at other proceedings in your case. The proceedings are being taken down by an audio-visual recording system, and there's a representative from the State Attorney's Office present to take note of any such statements. You have a right to remain silent, and your declining to answer questions or make statements will not be held against you. If you elect to give up that right and make a statement or answer a question, you have the right to consult with an attorney before doing so. And there's an attorney present. I can only see him over the monitor, but is that Mr. Kennedy?
It is, Judge.
Mr. Kennedy, who's an attorney with the Office of the Public Defender and with whom you may consult. Now, if I set a bond that you are unable to post, you have the right to place a request before your trial court judge to reduce that bond. And you may do that by contacting the attorney I'll be appointing to represent you. You have a right to contact that attorney as well as your bonding agency and your family members by telephone from the judge. Now, at the conclusion of the proceedings here today, in your case, whatever has happened, I ask and direct that you sign the paperwork the clerk will give you. If not permitted to sign it by the deputy, I direct that you accept that paperwork. It's not some confession or admission of guilt, but merely the minutes of the proceedings that would give you notice of your next court date and any bond conditions in your case. If we do speak together today, to whatever extent that we do, it would be important for us to have a meaningful conversation. So I ask and direct that you be sworn or that you affirm to tell the truth in whatever testimony you give here today. At this time I ask those of you who have a case, would you please stand and, as best you can, raise your right hand. Do each of you swear or affirm that any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? Very well. I deem that you've been sworn or so affirmed. Going to the take-out of order list, the first on that is Vernon Leckie. Is it Leckie or Leckie? Leckie. Mr. Leckie, you're here as a result of a warrant issued by a judge in Flagler County. The Flagler County authorities will be notified to pick you up, and if they haven't done that by the control date of January 11th, you'll be brought back before the court here so that other efforts can be made to make sure you're promptly on your way. I'm going to leave you in the no bond status endorsed on the warrant by the judge in Flagler County. Sign the paperwork the clerk will give you reflecting that next control date. Any questions? No, sir. Thank you. William Foster. Sir, what is your name?
William Foster.
Mr. Foster, you're before the court on 2 counts. One, a charge of aggravated battery on a person 65 years of age or older, and a charge of battery on a person 65 years of age or older. Can you afford to hire an attorney to represent you in this matter, Mr. Foster?
No, sir.
You qualify.
Very well. Give me a moment, please. I'm reviewing the arrest affidavit now. Find probable cause. 1 moment, please. And appoint the public defender. State's position on the bonds.
As set, Judge.
Who's that from the state?
I'm sorry, Jim McMaster from the state.
Yes, Mr. McMaster. You're agreeable to the bonds as they stand, which I believe to be the schedule amounts.
That's correct.
Defense position.
No objection to the schedule, Judge.
Very well. Give me 1 moment, please. Right. Ms. Foster, I'm going to go ahead and leave the bonds as they stand. $15,000 cash or surety on the aggravated battery charge, $5,000 on the battery on a person 65 years of age or older. No contact with Wayne Courtney or James Platt. I can't tell from this whether they were residing at the same location, so I will say this. Don't go to any place either of those persons are residing except for a one-time opportunity to obtain your personal belongings, and then only in the presence of a law enforcement officer. Do you understand?
Yes, sir. Is it possible to get
any firearms? What's that?
Is it possible to get that lowered? Because I am like flat broke, and I need to get out of
You
here.
can place a request to your trial court judge to reduce it, but given the circumstances that are alleged and the other appropriate factors, I deem that to be reasonable. Don't possess any firearms or ammunition, don't consume any alcohol or illegal drugs, obey any injunctions that have issued or that may issue, and appear for arraignment before Judge Brown on January 31st as reflected in the paperwork I direct you to sign. As I say, I believe that your attorney may well be able to get you to a bond hearing before that date. So you should be in good contact with your attorney. That will conclude your appearance today, Mr. Foster. That brings us to Dennifield Jordan.
Your Honor, Mr. Jordan intends to represent himself.
Very well. Ms. Jordan, the state alleges a charge of resisting an officer without violence. It's been represented that you're desirous of representing yourself in this case. Is that correct?
Yes, it is, Your Honor.
All right. If you later change your mind and desire the appointment of counsel, you can do that at a later proceeding. The court does find probable cause on this matter. Would you note in the minutes that the defendant declined counsel at this proceeding?
Yes, Judge.
State, what's your position on the volunteer?
Judge, it's set at 500. He's got a fairly insistent criminal history with felonies. The state would recommend 1,000.
Ms. Jordan, without talking about the case, don't talk about what happened or what didn't happen, but if there's something about your background or community ties that would help me make a fair decision on the bond, I would hear it. For example, how long have you lived here in Brevard County?
All my life.
Oh, you have any family members here?
Yes, I do.
Who would that be?
They stay on Cocoa Beach.
Okay. $1,000 appears to me to be a reasonable amount in this matter, given that it's as Mr. McMaster has said, prior criminal history and other factors. I haven't reviewed the arrest report. Conditions. Don't possess any firearms or ammunition and appear for your next court date on January 28th, as reflected on the paperwork I direct you to sign. Thank you, Mr. Jordan. That will conclude your appearance here. Emily Nip. Do you pronounce your last name Knip or Nip?
Nip.
Nip. Ms. Nip, you're here as a result of a warrant issued by a judge in Orange County. The Orange County authorities will be notified to pick you up. If they haven't done that by January 11th, you'll be brought back before the court here so that other efforts can be made to make sure you're promptly on your way. I'm going to leave it in the no bond status endorsed on the warrant and direct that you sign the paperwork. The clerk will give you reflecting that control date. Thank you. Theresa Kestel.
Good afternoon, Your Honor.
What is your name?
Kestel.
I couldn't quite hear you.
Last name Kestel. Can I talk to an attorney, please?
In just a moment, Ms. Kestel, you're charged with driving while license revoked, the felony variety of that. Can you afford to hire a lawyer?
I got a public defender.
She qualifies.
I couldn't quite hear.
I have a public defender.
Does she qualify?
Yes.
Okay, appoint the public defender to represent you. Did you
I want you to have mercy
over your
on
left
me.
shoulder is your I'm appointing the public defender's office to represent you, and there's a representative of that office over your left shoulder there. You may consult with him if you'd like. If I hadn't said so, I do find probable cause. Dave, what's your position on the bond in Ms. Kestel's case?
As that is fine with the state, Judge.
Right, very well.
I've never been in a car. It's always on a bicycle. And I've even been to the Titusville judge. And it's up to the officer's discrepancy to give me a ticket.
All right, why don't you hold off on that for just a moment.
have to go home.
Ms. Kessler, give me a moment, please. Defense, what's your position, Mr. Kennedy?
No objection to the schedule, Judge.
All right, leave it as it stands. Then don't drive a motor vehicle without a valid driver's license and appear for your next court date on January 31st, as reflected on the paperwork I direct you to sign. That brings us to Misty McSwain.
Thank you.
Thank you. Very well. Hold on just a second. What is your name?
Misty McSwain.
I'm sorry, what is your name?
Misty McSwain.
Ms. McSwain, there's two charges. One's a retail petty theft charge that they say occurred at Walmart, but there's also an on-site violation of probation, a felony probation based upon that new charge. Can you afford to hire an attorney to represent you on these matters?
No.
She qualifies.
One moment, please. All right. Find probable cause and appoint public defender. State his position on the bonds.
Judge, she's on probation. We'd ask that it be left at none until she appears in front of her DOP judge.
What do you recommend on the misdemeanor?
Standard bond.
Defense position.
Judge, on the new charge, I'd ask for a bond of no more than $500 and no more than $2,500 on the VOP.
Moment, please. Excuse me. But I'm given to understand some points here. There was a prior alleged theft earlier this year. Excuse me, in 2019. In 2018, I was still thinking that we're in 2018. It was in 2000 then, and that was when she was placed on probation for the possession of Xanax. There's some other driving issues that she's had, and a violation of the pretrial release order. But this is the only felony that she's had is the possession of Xanax, which she's on probation for, as far as I can tell.
As an adult.
Probation was only a year, though, but she's had trouble since then. Because what I have here would have imported a subsequent violation.
I believe that's correct, Judge. It looks like they did have a VOP proceeding on November 15th of last year where she was ordered into drug treatment.
Given the prior, make the retail theft 1,000 cash or surety, but the, she would still be well away from a threshold prison position. Is that correct? I mean, I understand that the court have discretion and there may be a bump, but that's my impression.
I believe you're correct, Judge. She did have some juvenile history, but it's too far out to score.
Make it 5,000 cash or surety on the onside UOP. So, okay, don't go to any Walmart in this county. Do you understand?
Yes.
All right. Appear for your next court dates on before Judge Lemonitis on the violation of probation on February 11th, and on February 14th, Valentine's Day, before Judge Friedland on the new theft charge. Sign the paper. The clerk will give you reflecting that. Any questions?
No, so how much would the bond be?
It's a total of $6,000. Kimberly Seymour.
Surety bond, Judge.
Very well. Brings us to Kenneth Sutton.
How you doing, Your Honor?
All right, Mr. Sutton, one more, please, sir. You're here as a result of a charge of criminal mischief. Can you afford to hire an attorney to represent you on this matter?
No, sir.
Does he qualify?
Yes.
Very well. One moment, please. Find probable cause, appoint public defender, state's position on the bond.
Judge, the state would recommend 1,000. It looks like he's got a prior burglary, a number of different misdemeanors, including resisting without, assault, possession of controlled substance felony, no driver's license 3 times, and Willis and another petty theft.
Defense position.
No objection to the state's recommendation.
1,000 is eminently reasonable. 1,000 cash or surety. No contact with the alleged victim. Don't go to 1024 Newbern Street. Do you understand?
Sure do.
Appear for your next court date, Mr. Sutton, on February 11th, as reflected on the paperwork I direct you to sign. Eric Zimmerman.
Your Honor, Mr. Zimmerman would be conflict.
Very well. Mr. Zimmerman, you're charged with battery on a law enforcement officer. Can you afford to hire an attorney to represent you?
Yeah, I can hire an attorney for me.
Zimmerman. What's that?
I can speak on behalf of myself.
All right. So
do I have an attorney withheld adjudication?
Okay, I have a question for you. Do you want me to consider the appointment of counsel to represent you at this proceeding?
Counsel?
Yeah, an attorney.
What kind of counsel are you talking about?
A lawyer.
A lawyer? Yeah.
It'd be conflict counsel. It'd be a lawyer from the Office of Regional Conflict Counsel.
Well, no, I heard I was granted public attorney.
And that would be a public attorney. Did he fill out a financial affidavit?
Yes, he did.
Nicole?
He did. He qualified.
Does he qualify? He does?
Yes.
All right, let's pass on this for the moment. I'm going to give Regional Conflict Counsel a call in just a bit, and we'll see. Take a seat back. We'll be with you in just a bit. I'd like to get your lawyer on the phone. Okay? That would bring us to Anthony DeSimone.
Yes, sir. DeSimone.
DeSimone.
Judge, he's already appointed.
Very well, one moment, please, sir. All right. And Mr. DeSimone, you're here as a result of charges of violation of probation. You've already been appointed counsel, I gather, on these cases.
Yes, sir.
That's correct.
Any argument as to my leaving this in the no bond status endorsed on the warrant?
Are you talking to me, sir?
State, that would be your request, is that right?
It is, Judge. He is designated as Anti-Murder Act.
Okay. Any argument at this point, Mr. Kennedy?
No, Your Honor.
Okay, direct that the defendant be held without a bond pursuant to the AMA. The state takes the position, Mr. DeSimone, that the court does not have the authority to give you a monetary bond at this proceeding. Yes. You should discuss this with your attorney, and if that turns out to be incorrect, you can apply for a bond from your trial court judge.
Yes, sir.
Thank you. You appear for your next court dates as reflected on the paperwork I direct you to sign.
Yes, sir.
Thank you. Gabriel Epstein.
Surely fine, Judge.
Very well. And Edwin, is it Freites?
He's already appointed, Judge.
Good afternoon, Your Honor.
Mr. Freites, you're alleged to have committed a violation of your pretrial release order. That's what brings you back before the court. You already have an attorney representing you. The judge endorsed on the warrant alleging that violation.
Yes, Your Honor.
That endorsed no bond on that.
Judge,
state your position would be that should remain. Is that correct?
That is correct.
Judge, there is a bond on the warrant.
There was a.
There is?
Yeah.
I'm sorry, I thought there was not.
There is. Booking took it away by they were wrong. This is a contempt
All right, let me see.
It's a $5,000 bond.
Actually, I had that as a note on my calendar also, Judge.
Yeah, I bonded out last night, but Your Honor, the reason why I didn't go take the urine analysis.
Sir, don't talk about that here.
You want to hold off on that? I mean, all right. Is the bond $5,000 or is it? How much is it?
Judge, it's $5,000 according to the warrant. Booking took the bond away from him in error. I don't know why they did that.
Okay. Mr. McMaster, do you agree that this should be $5,000?
Yes, sir. I have no information that would justify a revocation of it.
Very well. Leave it at $5,000 cash or surety on the defendant's release on the contempt violation. Appear for your next court date as previously set and is reflected on the paperwork I direct you to sign. Gignoliot? Jonathan Gignoliot? Is it? How do you pronounce your last name, sir?
It's Ginalone.
Ginalone.
Yes.
The state alleges a charge of trespass. I'd like you to give me just a moment, please.
Okay.
Let's inquire of the state before going further. Would the state be in a position to extend an offer to resolve this case by a plea of guilty or no contest today?
Not at this time, Judge. He's got an extensive history, much of it involving domestic violence with the same victim, which I believe is his mother.
Can you afford to hire an attorney to represent you in this
No,
matter,
Judge.
sir? Does he qualify, Nicole?
He does.
Appoint the public defender and find probable cause. State's position on the bond.
State would request $1,000 given the history.
No way.
Defense position.
Judge,
No way.
Schedule
Mr. Kennedy.
appears on the docket.
You want me to pay $1,000 fine?
What's that, sir?
You want a $1,000 fine?
No, $1,000 bond.
I got a $1,000 bond.
Okay, it's $500 now, but I'm
Okay,
setting it at $1,000.
Can I get an RR, Judge? I've never had an RR before. I'm from this county my whole life. I went to my mother's house to get my money.
Come on, be quiet.
This is crazy. I don't want to sit here. I can't even bond out my own money. Like I don't like the way things are going with me, Judge.
All right, $1,000 is an eminently reasonable bond.
I don't have my ATM card. I have the money. I don't have the card.
Well, you can contact the attorney I've appointed to represent you, and they may be able to help you with that. But don't call your mother. No contact with your mother. Don't go to the location of the alleged trespass. I caution you about calling from jail because they monitor the phone calls, so don't call her to help you with this bond, okay?
Why would I have to no contact when I just trespass at the not at her? It's a trespass at the apartment complex where the lady told me I can come on their property. I brought my friend there to rent there. I'm on the lease. The bills are in my name. I pay all the fucking bills for her.
Yeah, I was given to understand by the prosecution that
I live in the woods, Judge, and I have no bills, no nothing. I pay all her bills. It's all the bills are in my name, but I keep getting trespassed there. All I want to do is get RR so I can make my dentist appointment and go back to work because I support myself. I don't take no medicine. I don't want no money. I don't want no public defender. I don't want to pay nothing else. I'm not going to pay you guys nothing. I just want to get out of jail and go. Or you're going to keep me here.
Your mother had.
She ain't into nothing.
The arrest report. Your mother has previously requested that you be trespassed from there. I direct that you have no contact with her.
I'm not going to talk to her again. Just let me out of jail so I can get the hell out of here. I'm going frustrated. I got stuff to do. This is y'all been doing this to me my whole life.
If
you're in big trouble, God have mercy on Brevard County. Y'all are in big trouble. I'm just letting you know. You know that.
Okay. If
you know
If
that.
you're unable to post this bond, you can place a request to your trial court judge to reduce it. But
Sir, I don't have any money because I'm broke. It's a 10 because I have 41 cents in my bank because I take care of my mother. And I make more disability. And she has someone there. Her rent's only $34. How am I broke? It's a 10. She only gives me $20 a day. I work. You took my license so I have to ride a fucking bike.
As reflected on the paperwork I direct you to sign, don't use that language.
What language?
One
Freedom of speech language? Stop fucking lying to people then.
Jason Heilman.
Judge, that was $1,000. No contact with victim, no return.
Yes, ma'am.
Thank you.
Thank you. You encapsulated it beautifully. Jason Heilman?
Yes.
Mr. Heilman, I understood you were represented by Mr. Kernan, who I had conveyed a message to yesterday.
Yeah, it's Rich Austin.
Do you expect him, Rich? All right, they're in a firm together, I believe. But
correct.
Do you expect one of them to be present here today?
Yeah, but I guess not.
I'd like to address this.
I thought I had a DCF case today.
You've reached the law office of Kernan and Austin. How may I help you?
Yes, my name is David Silverman. I'm a judge here at the Moore Justice Center. I wanted to speak to Mr. Austin, or if he's not there, Mr. Kernan, with respect to a Jason Heilman who's before the court here for his initial appearance.
All right, I'd be happy to see what I can do for you. Just one moment, please. And I'm sorry, so David Silverman, let me just confirm that's DavidSilverman?
Yes.
And the phone number that I have on file for you is 321-617-7284, is that correct?
Yes, I left it yesterday when I was notifying them to contact the court regarding this matter. I had expected I might have received a call or that one of them might be wanting to participate in this proceeding because I believe they represent the defendant, Mr. Heilman.
And how do I spell Mr. Heilman's last name?
Heilman.
All right. And what's his first name, please?
Jason.
Thank you. Can I have you hold for just one moment while I patch you through to the attorney?
Yes.
Thank you. apologize. I was unable to reach the attorney. However, I will mark this as urgent and get it right over to the office.
All right. Respectfully, ma'am, I'm just going to go ahead and set this for further proceedings. I'm going to be taking no action as to the bond. He can go ahead and contact me, and if it is convenient to the court, we will consider this matter further upon his calling. Thank you.
All right. Thank you. Have a great day.
At this point, if I take no action as to the bond, it leaves it at none as endorsed in the warrant. That's the court's action, the court's or inaction, more accurately today. I'm just setting it to another date.
All right.
Thank you
so much.
Thank you.
Bye-bye.
So I'll be back tomorrow?
No, sir. I'm just going to set, when is the next court date on this, Nicole?
He has a docket sounding set for January 29th at 9:30 in front of Judge Mall.
Thank you.
All right.
That'll do it for today.
All right. Thank you.
Thank you. Casey Johnston?
Excuse me.
What is your name?
Casey Matthew Johnston.
This is a trespass charge. Let me inquire of the state. State, would you be in a position to formulate an offer in this matter to resolve this case today?
No, sir. He's got a very extensive history.
Okay. Can you afford to hire an attorney, Mr. Johnston?
No, I don't think that I need to for trespassing.
Okay. So if you later on you decide that you want the court to appoint counsel to represent you, you can apply for that as your next proceeding. Do you understand?
Yes, I'd kind of just like for him to say 5 days, 10 days, whatever. But just,
no, the state's not willing to make an offer. If you entered a plea to the court, you would have no assurance that you couldn't be given the maximum sentence, and that would be a year in the county jail.
For trespassing?
No. Do you want me to consider the appointment of counsel to represent you now?
If you think that it'll help me, I mean...
It's not up to me, sir.
For simple trespassing...
I'd recommend to anyone in your situation to seek the advice and representation of a lawyer. Do you want me to consider the appointment of counsel?
I've been arrested for trespassing before, and I got a counsel, and when I told somebody about that, because I got almost a month, they said if you get a simple trespassing like that, you got to do that yourself. That's why I was asking you.
This question is really pretty basic. Do you want me to consider the appointment of counsel or not?
Just go ahead and get counsel.
Does he qualify?
Yes.
Appoint the public defender to represent you. State's position on the bond.
I'm going to ask for 1,000, Judge. He's got at least
position.
5 or 6 more. Schedule, please.
I had the the pretrial release defendant profile form.
Okay.
Defense position, Mr. Kennedy.
The schedule.
You're going to get 1,000 cash or surety. Conditions: don't go to the location of the alleged trespass. Appear for your next court date, and no contact with the owner or alleged victim. Appear for your next court date, January 28th, before Judge Ingram, is reflected on the paperwork I direct you to sign. Early Lolley.
Okay, thanks.
Well, Ms. Lolley, you're charged with a trespass. Let me inquire of the state. The state would be in a position to formulate a position on this matter.
Give me just a second, Judge.
In the event he were to enter a plea of guilty or no contest, what would the state be recommending?
The state would recommend 2 days in jail.
With credit for the 2 that he has?
Yes.
Does he have 2 or 1?
He's got 2.
He has 2.
He has 2. All right, so he'd be adjudicated guilty. There'd be mandatory court costs that'd be required to impose. 2 days in the Brevard County Jail, credit for 2. Are those terms acceptable, Mr. McMaster?
Yes, sir.
Did you understand those terms, Mr. Lolley?
Yes, Your Honor.
You don't have to enter a plea of guilty or no contest, and those terms are on any terms. You have the right to a trial and the right to a lawyer to represent you. Do you understand?
No contest.
All right, can we furnish him one of the plea forms to have him read that over? Why don't you read that over, and I expect we'll be able to take you up before the end of the take out of order group if you'll read that over now. Thank you. Take a seat back and do that. Thank you. Eric Manchester. What is your name?
Eric Manchester.
Miss Manchester, you're charged with aggravated assault with a deadly weapon. Can you afford to hire an attorney to represent you?
No, sir. I'd like to speak to my public defender for a brief second.
Does he qualify for the appointment of the public defender's office, Nicole?
Yes.
Appoint the public defender. Find probable cause? Sure. Go ahead. You may go ahead and consult now.
Okay. Your Honor, I found out, I came home, found,
You don't want to talk about
my children's lives.
State, what is your position on the bond? I deem that I found probable cause. State, what is your position?
Standard bond on this one, Judge. He has some history, but not bad.
You call it to 5,000, is that correct?
That's correct.
Okay, defense position.
no objective schedule.
Give me a moment.
Your Honor, I'm a single father with 2 kids. I rented out a room to a gentleman. I came home, found out he was dealing heroin out of the house, and I chased him out. That's all I did.
Me. The fact that you're not able to, for a moment,
I called the cops. I'm
the advice to not to talk about the case doesn't give me any great confidence.
My children's safety is at stake. Yes, I will do whatever it takes to save my children. Yes, they're at home right now with this gentleman.
Okay, give me a moment.
I cannot afford the bond. I have no family. I cannot afford the bond.
Take a seat. Sit down. Be with you in due course. Justin, how did is it Protel? How do you pronounce your last name?
Protelsh.
Protelsh. All right. In terms of violation of probation, you already have the public defender already representing you in this matter, I gather.
Yes, sir.
The judge endorsed no bond on this warrant. State that your position is that it should remain.
Yes, sir.
Any objection, defense?
The warrant, Judge.
All right, leave it at none at this point. No bond. Appear for your next court date on February 26th as reflected in the paperwork I direct you to sign. Thank you. Caleb Reed. What is your name?
Caleb Reed.
I need a moment here because my computer it was having some difficulty. I restarted it and it's not coming back up. Is yours moving any particularly slowly at all? Do you have access to ICMS? You do not.
What do you need?
We're going to look at the arrest report in this case.
I can pull it up.
It's 2019 CF 10722. And could you, I don't have access to email because this won't restart. Could you email Core Technology to come here to see if they can restart this computer? If you have it there, I'll come over there and take a look. Ms. Reed, the state alleges charges of burglary of an occupied dwelling and possession of burglary tools. One moment, please. You have it up? Oh, you printed it out. Oh, thank you. Like the old days. Give me a moment, please. Find probable cause. Can you afford to hire a lawyer, sir?
No, sir.
Does he qualify, Nicole?
Yes, sir.
Appoint the public defender. State's position on the bond.
Judge, normally I'd say I'd agree to less because of what's shown on the PTR report. However, we are showing his juvenile history here in Brevard. Between the years of 2011 and 2016, he had 7 battery, aggravated assault, battery law enforcement officer cases, battery on a district school employee, board employee, all of which he was found incompetent to stand trial on, and several of which they found he was not restorable to competency.
What do you recommend here, sir?
I recommend that we leave it at the current status that as set for the bond, and I would suggest that either the state or the defense might want to be moving for a competency evaluation as soon as possible.
Defense position.
Judge, no objection to the schedule.
Leave the bonds as they stand. Conditions, no contact with Zachary Sheely. No contact with Charles Turner except through your attorney. Don't go to the location of the alleged offense at 2311 Lee Avenue in Melbourne. Appear for your next court date on January 31st as reflected on the paperwork I directed you to sign. Thank you. I am. It's, is this one? Nothing comes up? Wait.
Hey, what is my bond?
It's Tony Sarod. I hate to do this because you print the next one as well. You can take a look at this computer. It's just not. We can email Court Tech. Thank you. What is your name?
Troy Sayard.
Ms. Sarod, you're charged with grand theft of a motor vehicle. Can you afford to hire a lawyer to represent you in this matter?
No, sir.
Does he qualify, Nicole?
Yes, he does.
I'm sorry, ma'am, I could not hear you.
Yes, he qualifies.
Appoint the public defender. State, what's your position on the bond?
He's got an extensive juvenile history, Judge. This is obviously one of the few adult cases. So we'd recommend that it left, well, it's set currently as no bond on the 923.
That's how it has come in. It was the, for whatever reason, they put it not on the arrest report.
I see that. I'm just trying to figure out why.
Because you've got a pending case.
Ah.
Judge, I'd ask for the schedule of 2000.
He's got a pending ag battery on a person 65 or older, so I'd ask that it be left at the no bond at this point and let him go before the trial court and figure out what's going on with the other case.
Well, the state can later move to revoke the bond in that case. But we're here on the grand theft of a motor vehicle case. The arrest report may suggest either trespass or potentially a burglary of the residence as well.
Judge, I'm sorry, the defendant wants me to ask for a $10,000 bond.
I mean, if my bond said at no bond, I'd rather have a bond than no bond.
Yeah, and I'm considering that, and that's assuming I was setting a monetary bond, Mr. McMaster. Would you have any recommendation?
I'd recommend 15,000, Judge. I think the PTR sheet does reflect most of his juvenile convictions.
Yeah. Can you advise me as to what the bond was on the aggravated battery charge?
15,000.
Yeah, it was 15,000.
15,000. I'll set this at 15 as well. That appears to be reasonable and within the defendant's financial ability. No contact with the alleged victim, and don't go to either 451 Marina Park Drive in Titusville or 2585 Buena Vista Drive in Titusville. Appear for your next court date is reflected on the paperwork I directed you to sign.
Sir?
That's February 7th.
So
Yes.
I can't go back to the marina in Titusville?
No, that the police responded to there because that's where the alleged vehicle was crashed. No, I can't. No, don't go back there. Don't go back to that location.
Yes, sir.
I don't. Okay, appear for your next court date is reflected on the paperwork I directed you to sign.
Yes, sir.
Frederick Walraven.
Surety bond, Judge.
Very well. And John Skinner.
You had Ricky Watson before that.
Oh, I'm sorry. Oh, we skipped Ricky Watson. Ricky Watson. Thank you.
It's a bond surrender.
Didn't mean to skip you there, Mr. Watson.
It's all right.
Give me just one moment here to see what's happening. Represented by Regional Conflict Counsel on this matter. Let's pass on this for the moment, give them a call.
This is just a bond surrender.
I know, it's just a bond surrender, but I'm calling him anyway, so there's no harm. John Skinner. Ms. Skinner, you're charged with possession of a controlled substance and possession of drug paraphernalia. Can you afford to hire a lawyer to represent you?
No, sir.
Does he qualify for the appointment of counsel?
He does.
You don't represent Brianna Lee, do you, Mr. Kennedy?
No,
your
sir.
Office? Appoint the public defender. State's position on the bond.
Just checking his history. He's got 8 prior felony convictions. Looks like 14 misdemeanors. State would recommend 10,000.
Is that 10,000 overall?
10,000 on count 1, 5,000 on, or 1,000 on the paraphernalia.
Defense position.
Judge, I'd ask for the schedules that appears on the docket.
Give me just one moment, please. You print. find probable cause. The controlled substance that's alleged was methamphetamine. The paraphernalia, however, was sort of heroin-based, as I gather it. Mr. McMaster, my impression of the defense record is primarily theft, some
I've got,
traffic, and some drug use.
it looks like 2 counts of fraudulent ID, 3 counts of possession of controlled substance, and then the more recent case was 1 count of uttering, 1 count of grand theft, and 1 count of depositing checks. And the 14 misdemeanors, I think, were spread out all over the place.
One moment. All right, we'll make it, I agree that it should, the schedule is not adequate in this. On count 1, but we're talking about the green circular container with a small residue of crystal substance, field tested to be presumptive for methamphetamine. On that, we'll make it 5,000 cash or surety. On the paraphernalia, which includes, according to this, baggies, needles, scale, a spoon, make that 2,500 cash or surety. Conditions: don't possess any illegal drugs or illegal drug paraphernalia, don't consume any illegal drugs, appear for your next court date on January 31st as reflected in the paperwork I draft to sign. Thank you. I need to take a brief recess. My computer